what the heck's going on in 2025? I thought we had a lot going on in the last two, but no, wait, there's more. There's even more shifting legal landscapes. There's a lot of different topics that are hitting because whenever you have a change in administration from the federal government, people vote, there are results. Okay. And at the federal level, we used to see things happen slowly, right? You'd have an election and then they'd say, I'm going to do this, that, and the other. And then, 3 years later, they do half of it, right? Imagine a road construction issue, right? That's just something I'm throwing out there, right? But, you wait a couple years and all of a sudden you notice orange barrels are up everywhere. Not so fast now, though. Actually, really fast now. What we're seeing in the last two administrations has been almost warp speed as far as I get in and I'm making changes. I want to ask a little bit, Tony, on the topic of discrimination. Okay, we have a lot of employers here. Can you tell us if there's been any major changes out there in the last year that our participants here on this webinar need to know about? Because I think there's been some significant things people might not have been tracking yet.
Yeah, absolutely. And so I think on this topic, we're going to talk all things discrimination. And so, as you know, there's a lot of anti-discrimination laws, both at the state and the federal level. And generally, these laws prohibit you from treating employees differently based on a protected characteristic, such as race, gender, disability, etc. So, what we're looking at, there's a couple big updates and things that we're watching right now. First is the federal government's focus. And so Courtney and Cliff will talk a little bit later about DEI, but we've had a lot of executive orders this year. And as Cliff mentioned, things are moving at rapid pace. And one of those executive orders back in April told agencies to deprioritize disparate impact discrimination claims and put resources towards intentional discrimination claims. And so what the EEOC did is they came out publicly and said, hey, yep, we intend to comply with any and all executive orders, and we will prioritize remedying intentional discrimination. And so when I say disparate impact claims, what I mean is a situation where you have a neutral employment policy that has an unequal outcome of employees of a particular, usually race or sex. So what this means is that the EEOC's focus is not going to be on disparate impact claims, it's going to be on disparate treatment claims or intentional discrimination claims, which means that typically an employer is treating someone differently based on their race, their sex, or a protected characteristic. So this is something to keep in mind for the next probably 3 years on where the EEOC is putting its focus. And on that point, the second big thing that we're watching is religious accommodations. So a couple years ago, the Supreme Court raised the bar for denying a religious accommodation, which we'll talk about in a little bit. But the EEOC came out just 3 weeks ago and they put a presser out there saying 200 days of EEOC action to protect religious freedom at work. And they've came out and they said that they are prioritizing making sure that people don't have to choose between their paycheck and their faith. And their position is that, religious protections have taken a back seat and they are all in on enforcing and charging and coming after religious discrimination claims. So those are the two things on sort of the federal government's focus. On the case law side, we had another big Supreme Court case just this summer that changed the Sixth Circuit's background circumstances rule in what's called reverse discrimination cases. So now everyone uses the same Title VII framework, which I'm sure we'll get into a little bit. And then the last thing is a Michigan Supreme Court case, not a federal case, that looks at and scrutinizes those 180-day limitations you put in your handbook and whether or not those are able to be enforceable. So, lots of things we're looking at right now. That's kind of a broad overview.
Okay, excellent. I did want to raise one thing, literally raise. There's a program called Raise. It was around for years and then was discontinued under the Biden administration and recently brought back in. Then we were talking a little bit about misclassification, but there's lots more reasons why you didn't pay somebody overtime. You forgot. You didn't know that you had to add a bonus into the overtime calculation, right? There's things that can happen where you go, uh-oh, we made a mistake. We misclassified the person. We just forgot to do this right. We didn't calculate it, or a payroll program. There's a million reasons why you can innocently not pay somebody overtime. It used to be you're in trouble because the only way you could settle, the only way you still really can settle a claim is if a judge tells you, there you go, you settled it properly. Well, nobody wants to get in front of a judge. That means you've been sued, or the Department of Labor says it's okay. You only get there generally if someone brings a claim against you, or you voluntarily do that. But this new raise program is something you can voluntarily do. You can go to the Department of Labor, you can ask to be part of it. This is new. It's something to help people, because a lot of times people say, well, what do I do? I mean, if I go tell everybody they're entitled to overtime, they might sue me and get double damages and attorney's fees, and then they don't sleep at night and they're afraid that somebody's going to get sued, maybe them. So what this does is say, hey, look, come to us. We'll help you out. We'll take a look. You do an audit of yourself. You bring it to our attention. You should be good. But you can't have been part of an ongoing suit or a Department of Labor program. You can't have been part of this issue. You can't have, in the last 3 years, a Department of Labor finding or a wage and hour claim against you before you do it. Pretty big change, right? Pretty significant. So we hear all the things that Tony's talking about, which again, very significant changes in discrimination law, especially on, we'll talk a little bit more, I think, in detail on the religious discrimination in a little bit, which I think is big, but all the discrimination cases, even potentially the way that we look at it. So a lot of stuff. But Tony, you talked a little bit about religious accommodation, but can you tell me how it shifted? Like, what are they actually doing? My understanding, it's a pretty significant change, my understanding.
Yes, so the Supreme Court in 2023 in Groff versus DeJoy, in that case, Mr. Groff was a postal worker and he asked not to come into work on Sundays for religious reasons. And the lower court said, the lower court used to say, if an accommodation caused more than a de minimis cost, basically, anything more than that low bar, you could deny it. Well, the Supreme Court in Groff clarified that showing more than a de minimis cost, that's not really sufficient. That's not what undue hardship is under Title VII. So instead, the Supreme Court said, no, no, no. Undue hardship is shown when a burden is substantial in the overall context of the employer's business. So now what we're looking at is the nature. We're looking at the size of the business, the operating cost of the business, and you really need to, and Cliff and I will talk about it a little bit later in the program, but you're going to have to document and be able to show, financially what undue hardship looks like if you deny a request for a religious accommodation. So this is a huge jump from the old sort of more than de minimis standard where any sort of small cost you'd be able to say no. So what that means is that coworker complaints, if you deny a religious accommodation because other employees won't like it, that's not enough. If you don't think your customers will like it, that's not enough. You got to try schedule changes. You got to try temporary reassignments. And if you deny it, again, you better be able to actually substantiate the undue hardship there. So if someone comes to you and says, if you run a restaurant and says, I don't want to work on Saturdays, I have, a sincerely held religious belief, you're gonna have to engage in that interactive process, try to schedule their shifts, swap shifts. And if you say, well, everyone will be mad, you're going to be in trouble. And so, again, that's kind of where we're at now in terms of the standard. And now we've got this press release by the EEOC that says 200 days of EEOC action for religious freedom. So they are prioritizing coming after religious claims. They're touting the more than 10,000 religious accommodation charges they've received since the Biden administration. So they're focusing on this now. This is a big deal. So what we want you to do is keep your ears up and make sure that you train your employees. You're listening. If someone emails or tells you, hey, I've got your dress code policy conflicts with my sincerely held religious beliefs, or I don't want to work on Saturdays, you cannot just deny it. You're going to have to engage and talk to the employees. So it's a big deal. You cannot just deny it now, or you could get hit with an EEOC charge because again, they're coming after these cases. You could have a lawsuit. There's damages, there's back pay. It's not good. So just, we want to emphasize being careful here.
Yeah, we'll probably touch on this a little bit later too on the religious, but can you give me a couple examples of how the EEOC's really some cases, for instance, that you've seen?
Yeah, and there's a couple types. So the EOC is there's religious accommodation cases related to COVID-19 exemptions. So these usually involve healthcare providers, hospitals. So they've published $1 million settlement against Mercy Health related to a vaccine mandate. The Mayo Clinic they've come after. And then there's other cases, sort of standard, quote unquote, standard religious discrimination cases where it's related to dress, it's related to Saturday or Sundays off, or requesting time off for the Sabbath. So, specific examples, and Cliff and I were talking about it yesterday. P.F. Chang's 2 days ago, they got hit with, they were required to pay $80,000 for religious discrimination when they didn't hire someone because of their request to take Sundays off. Buffalo Wild Wings, 3 weeks ago, they were ordered to pay $47,500 because a candidate were requested to wear long skirts, and one of the managers said, "Yeah, our servers don't typically wear long skirts." The Venetian Las Vegas had to pay almost $1 million for refusing to accommodate sincerely held religious beliefs. A staffing company called Logic Staffing failed to hire a Muslim job applicant because he asked for religious accommodation to attend Friday prayer. The Marriott, the EOC sued because a sales executive requested to observe the Sabbath in accordance with her faith. A dental clinic ordered to pay $61,000 for firing an employee over her request to wear a scrub skirt instead of typical scrubs. So these are all real cases, literally in the last couple months. So the EOC is coming after these cases. They're taking it seriously, and it can be really expensive if you don't pay attention.
Tony, it's interesting. I remember there was a jury verdict not too long ago here in Michigan on one of the COVID vaccine issues, a sincerely held religious belief case, and the jury hit, I believe, for over $12 million. And so it's real, it's happening here, and it's happening now. But this predates the whole idea of the religious accommodation. It's not just something that came out of the COVID, 19. I think sometimes we get a little fixated on the issue of, well, it's about vaccines. It's not about vaccines. It's more than that. And what the Supreme Court has done, it sounds like, is, and employers need to understand this. I need Sundays off because I go to church and I think that's a sincerely held religious belief. What you should not do is you shouldn't get them into deposition and say, okay, here's the 10 commandments. Which one have you broken? And so, oh, so you're not a real Christian. Uh-huh. So, yeah, so you go to church, but you pick and choose. That's not going to go over well when you go into court. There's more to this. If a person has a sincerely held belief, the next question is, does that belief pose an undue hardship? And I don't want to get into it because we're going to go a little bit more, but there's real money at stake, and it's not what it used to be. And it's sometimes people say, well, your religious belief isn't as important as a disability discrimination case. And the Supreme Court, United States Supreme Court, has said, not so fast. That's not the way it should be. We got it wrong before, and that's where we're at now. That's shifted. That's a seismic shift. Going to the Friday prayers, the one that was out in Seattle you talked about, sizable, and we'll talk about it a little bit more. It's not just a $20,000 or a $10,000 hit, a big time hit, because the person didn't just say, hey, I'm going to be off on Friday. They said, hey, can I have some extra time off to go to pray? And you know what? If I can find a mosque nearby, don't worry about it. I'll just go there and I won't need the accommodation. And they said, yeah, we don't need to hire you. Well, you got hit with a lot of money. We have to train our managers, our hiring professionals, not to just simply scoff at religious accommodations because it can get you really quick with a big penalty. So, okay, now let's talk a little bit about here. There's a big Supreme Court case about reverse race discrimination, and I think people need to hear about this. This is new. It changed the law, and I think individual employers sometimes don't understand how the whole race discrimination process works in the first place. but this did change it. Can you explain a little bit about that one? Because I think this is going to be significant for employers to make sure they're doing the right thing when they make decisions on hiring and firing.
Yeah, absolutely. So Ames, which very recent Supreme Court case, ruled unanimously, which is unique,
Mhm.
to reject the Sixth Circuit, which Michigan is in, their background circumstances sort of rule. So plaintiffs who are in a so-called majority group, they're not typically what you considered a minority. Um, and so what happened in this case is a heterosexual woman was denied a promotion and she was subsequently demoted while a younger gay man stepped into her former position. And before her demotion, a gay woman took over the promotional role. So she filed a discrimination complaint with the EOC and then sued under Title VII, alleging discrimination based on sexual orientation and sex. And at that time, because she was what courts in the Sixth Circuit would consider a majority group as a heterosexual woman, the Sixth Circuit applied something called the background circumstances rule, which required her to show that the employer who's allegedly discriminating against her was the type of employer who unusually discriminates against majority groups. So this was kind of a higher bar in these so-called reverse discrimination cases. And the Supreme Court struck that down unanimously, and they made clear that plaintiffs must all be treated alike and that Title VII protects um, any individual uh, any individual from discrimination based on sex or sexual orientation, regardless if you're in a minority or a majority status. So I think there's some misconceptions about what this case actually said. So now Title VII, it treats everyone the same, regardless of whether you're in a minority or you're in a majority group. So for your hiring professionals, for your managers, if you get hit with a sort of sex discrimination claim or any Title VII discrimination claim, there's now not a higher bar to hit for so-called majority group plaintiffs. So it sort of evens the field there, and frankly, there's a little bit more litigation risk because it's less of a burden for plaintiffs to show now. So big update for Michigan employers.
So put differently, the old adage of, well, is anybody here in a protected class? The answer is always yes.
Correct.
Always yes, right? That's what I think is the biggest takeaway here is everybody's protected. I can't tell the audience here clear that if you take one thing from today's seminar, it is what has significantly changed in 2025 is a loud and clear message from the federal agencies, the United States Supreme Court, and the federal government as a whole that you may not discriminate against people under the law, period. So, all the things we've always done as far as EEO policies, as far as non-discrimination policies, none of them have to change. None of them have to change. You don't have to do a thing, but you do have to apply them. And you have to apply them so that no one, doesn't matter if they're a white female, if they're an African American male, if they're an Asian American non-binary person, it doesn't matter. What we have to do is we have to ensure that we don't discriminate based on a protected classification, which is race, sex, age, and all those other things that we have under the law that we've always had under the law. So I think that's the takeaway is this law took away the requirement that you have to be that special kind of employer that discriminates against majority people. That factors out of it. So a big deal, I think internally it's a big deal just to make sure people understand that. So when they do hiring, layoffs, we'll get to all these things later, firings, terminations, just make sure that what you're doing is a legitimate business reason. Period. There you go. Um, I understand as far as a shifting change as well that I wanted to talk about a little bit is the EEOC taking out this concept, and we'll probably talk a little bit more, this concept that they've had historically that when you go into a discrimination case, they look at the impact, right? They say, has this non-discriminatory purpose decision? We decided to do something. We didn't really want to do it for any, real discriminatory reason, and you can't prove that we did. But does it have a discriminatory impact on a certain race or a certain gender. Now, if you do that, then what they call that was a disparate impact case. So you could try to prove a claim saying, well, maybe they didn't think it was going to impact this, but it did. And the EEOC has just come out and said this year, forget about it. We're not doing that anymore. We're not looking at the impact. We're looking at what you were doing. So not only did they take the bar off to say everybody's now covered, they've also said, oh yeah, but on the other side of it, we are looking at why you did what you did. That doesn't mean the courts won't continue to look at disparate impact and that people won't sue you. I'm not saying you shouldn't look at that, but that is a significant change from the EEOC. So the federal government agency in charge of looking at what you're doing wrong seems to be looking at, are you discriminating against people because of their religion? Don't put a lower bar. Are you discriminating against people because they fit into a classification? Don't worry about what classification. And more importantly, when I say discrimination, what is it that you're doing and why is important, not necessarily the impact. Not the, and Courtney and I will talk a little bit more about the equity concept and how that fits in there. So those are pretty sizable changes that employers are going to have to not change their rules necessarily, but change the way they manage. So Courtney, going to you, I think recently there's also been a Supreme Court case, Rayford. And can you tell us a little bit about what happened in Rayford? Is that a pretty big deal?
Yeah, so excuse me, Rayford versus American House Roseville. That's a Michigan Supreme Court case that just came down. And this case addresses that pesky 180-day lawsuit deadline that Tony mentioned earlier. The facts of this case basically involve a nursing home employee who signed a handbook acknowledgement a week after she began working with her employer. The acknowledgement included that limitation period, that 180-day cap on when she could bring any lawsuits or claims arising out of her employment. Unfortunately, several months after she started working for the employer, she was terminated. And then about roughly 3 years, not quite 3 years after the fact, that same employee filed a complaint alleging that the employer or that nursing home violated the Elliott Larson Civil Rights Act. And in her claim, she said that there was harassment, there was retaliation, that she was working in a hostile work environment, and that there was discriminatory acts against her. The nursing home immediately argued, well, this wasn't timely. You failed to file your lawsuit within that 180-day limited deadline period. And, as a result, basically you're barred from bringing this claim. The case, obviously, like I said, progressed. It went all the way to the Michigan Supreme Court, and they found that these clauses aren't necessarily void, but they are also not automatically enforceable anymore. You can't just presume that they're valid just because they exist and somebody signed off on it, right? A lot of times, especially like in the handbook situation, which I think a lot of us in our practice group have seen, it's boilerplate language. But the courts are now applying what they're calling the reasonableness test or review to make sure whether or not the inclusion of that clause actually makes sense. Is it reasonable? And they're giving it extra scrutiny when there's evidence that that clause wasn't negotiated over. In this fact pattern, for example, the employee didn't sign it until a week after. There was no negotiations. It was just, hey, you already started here. You've already, accepted your employment. We just need you to sign this document. She didn't have any say, so she probably didn't look very closely at that clause. And that's a situation where the reasonableness review would really factor in nicely. So, for example, if someone were to bring a discrimination claim 9 months after the incident occurred, and their handbook had that pesky 180-day clause in it or limitation, a judge might actually let it through if they think that it was unfair, or if it was hidden, or if the employee just didn't have a chance to fairly negotiate or discuss it. So to me, that's a pretty big one. And I think a lot of employers should be checking their handbooks for that, because I know quite a few who have similar language in place.
Yeah, I drafted it. I draft it all the time. This is outrageous.
You're the person.
Well, I would have written a dissent, because I put it all the time, because, when they make these laws, right? When our friends at the state level and the federal level make these laws, I think they always get it wrong when they tell people how long they have to file a lawsuit. I'd like to make the decision on how long you have. I know it says 2 years, but let's make it 180 days. That's awful nice, right? I thought it was great that us attorneys could do that. And finally, what the court basically said is, wait a minute. Hold on a second. We wrote the laws in the legislative sector, not the employer. What are you doing? You're limiting people back. So to a certain extent, this isn't something that I can sit there and say, yeah, I'm shocked by, right? I mean, this is not something that we should all be shocked by, but it is significant because this is what it means. Remember, we've had a lot of these seminars where we talk about how long do you have to keep documents, right? How long do you keep documents? Well, the law might say you can throw it away after a year. But what if you've got a person now who's got a 3-year statute of limitations under Elliott Larson? So the day they get fired or the day they got demoted or whatever negative thing that happened, and they come back in 2 years and 11 months from now and they file their lawsuit and they remember it like it was yesterday. And you don't remember it at all. And half the people that were there are all gone and you threw those papers out the door. This is a pretty big deal. What this does now is it places on us a lot of burden. So I guess that gets to you, Courtney, just kind of to finish this up. What are some steps we can take in HR to reduce discrimination risk, but some other associated issues to think about?
Well, going back to what you said about everybody is protected now, right? Piggybacking off of some of Tony's content. I think the easiest thing, right, in this situation is to not treat somebody differently, right? Because of their protected class. That would be the easiest little caveat that you could place on this. And an employer can, never go wrong by fostering, that kind of inclusive, respectful workplace and ensuring that their employees are feeling, valued and respected and can come to management openly and discuss things, right? That's the, if the world was rainbow and sunshine, so what I would recommend to reduce risk. But in reality, developing strong documented anti-discrimination policies is probably the best place to start. That's going to entail conducting regular audits with your HR professionals or your legal counsel to ensure there's no bias in them. Review your recruitment and hiring promotional practices. You want to make sure that your action is based off of neutral criteria and not on just some bias factor. This will not only help you widen your actual application pool, but it will ensure fair workplace opportunities from interested candidates. Another one is provide regular and inclusive training for your staff and your employees, especially your managers who are going to handle a lot of the day-to-day focus of these policies. Make sure that they actually understand what's expected of them, not only by the employer, but under the law. And another big one is just establish clear and accessible procedures for reporting concerns. You want employees to know where to go, what they need to include. And this goes back to your record retention comment. This is important for just record keeping to protect the employer in the long run as well. Just having these systems in place so that when or if a situation arises, nobody's caught off guard and there's a system that can be followed step by step. Those are probably the best ways of just ensuring, I can't say ensuring, but reducing potential risk.
It goes back to the old, this is the worst employee I ever had. Of course I had to fire them. And you get the personnel file and it's got like one piece of paper in there. It's their application. And you're like, well, what happened? Did you write them up? Wow, we warned them all the time. Well, who warned them? I don't know. It was 3 years ago. I can't remember. Okay.
Yep.
Well, there you go. Now you know why you probably should, get on top of these things. So it's an interesting way to look at things that we're being forced now to be better at HR, be better at record keeping, be better at doing what we have to do to keep our records in place because we can't shorten the statute of limitations. And in many cases, those are long statutes. So it's not that it's the end all be all. The Supreme Court did not say you can't limit statute of limitations. They basically did, but they sent it back to say, okay, in this circumstance, is there a legitimate reason that you should shorten it here? In most cases, I think what I'm reading from the decision is you're not going to be able to in most occasions. Now, what we can do is look at certain people, right? Certain jobs, high-level executives, employment agreements. There might be an opportunity to do that for those people or for some people, but we can't just do it for everybody like we used to in your handbook. And I think that's great. I appreciate it. Courtney, Tony, great stuff. If you have any questions, please call them. I mean, we just think that there's a lot to talk about in developing laws.